and welcome to each one of you. Thank you for joining us. Thank you to John Chamberlain and Brennan Hodges here for sponsoring this first Practicing Physicians of America Zoom conference. I'm Judith Thompson. I'm a general and breast surgeon in New Braunfels, Texas. I'm the chairman of the board for Practicing Physicians of America and lightheartedly refer to myself as the team intern and scut monkey. I do many of the behind the scenes nuts and bolts activities necessary to keep things going. We're going to begin with a brief introduction of each of the board members, and then Brian Dixon is going to give us an update. Following that, we'll go over to Wes for an MOC update, and then we need to move on to Marion, who will bring us up to date with what's going on at the legislative level. And Marion has said that at 12:50 she needs to be gone, so we'll keep that in mind. So Wes, want to introduce yourself?
Thanks so much, Wes Fisher, cardiac electrophysiologist. I work out of the Chicago metro area. Myself and Marion were the two co-founders of Practicing Physicians of America some time ago, when it was at its very nascent stage. And it's been a delight working with these hardworking individuals that are here with us. We also have joining us Laura Feldman, who happens to be one of the attorneys with Robinson Curley for the mock stuff. So I'll get back to that issue once we return here. So thanks.
Dr. Wax.
Thanks very much, Judy. Thanks to all for putting this together. I am Craig Wax. I am in a solo private practice in southern New Jersey. I'm a family physician by training and practice, and I practice preventative health. I'm the VP of Health Policy for PPA, and I've worked with the other members over the years to try to advance our causes of freedom for patients and physicians. I'm the host of Your Health Matters on rowanradio.com, which is 89.7 WGLS FM. I'm a longtime writer for medical economics, and I previously served on the medical economics board. And I've been blogging since 2012 at Independent Physicians for Patient Independence, which is the letters IP, the number 4PI, sort of a palindrome, IP4PI.wordpress.com. Thank you.
Thank you. Dr. Mass.
Hi, Marion Mass. I'm a pediatrician in the Philadelphia area. I've done a little bit of everything in medicine. I started in hospital work. I worked in a small independent practice that was forced to close several years ago, and now I am an employed physician in a large hospital system. I'm a writer. At times, I've written for some national pieces, including the Wall Street Journal, the Philadelphia Inquirer, the Hill, the Washington Times, and the Washington Examiner. In addition, I write for my local newspaper. I'm on the editorial board there and help with our County Health Improvement Partnership. And I'm really, really happy that we're having this conversation, and I'm excited to tell you about what we've done to get many physician groups together and to take them to have a presence in Washington, D.C. Thanks so much, everyone, for participating.
Hey, Brennan. Thank you, Dr. Mass. Has Dr. Al-Ajba joined us?
I have not seen.
Okay, so we will move right along to Dr. Brian Dixon.
Hey guys, my name is Brian Dixon. I'm a psychiatrist here in Fort Worth. I'm in a direct pay practice, meaning I don't have to do any insurance companies, and it's awesome. I was a triple board resident, so I was trained in pediatrics and psychiatry, so I feel like I have a pretty good gist of how the medical realm works, as well as the practice world. And then I do a lot of side things, including teaching at the local medical school. So, and I'm happy to be here, and I appreciate you letting me chit chat a little bit early because I'm actually in clinic as we speak.
Okay, Brian, thank you. Go ahead with your update.
Yeah, so what I kind of bring to the table, I'm a general board member for the Practicing Physicians of America. With my background and my passion is mainly marketing. So what we do nowadays, what my business coaches have taught me is that attention is currency. And so in a world where we are saturated with so many emails and updates, having a coherent, focused message is super, super important. And so Practicing Physicians of America has been working very diligently to keep a focused message, to send out email newsletters as well as have a social media presence. That's what I spend most of my time on, and so that we can continue to build the group collective. I work with Marion to hopefully get some conferences up and running. I'm a support staff, and I really appreciate the opportunity to mix and mingle with entrepreneurs as well as employed docs, because every physician matters, every physician's life matters. And I spend a lot of time working on burnout as well. So I will go mute, but I'm available to answer questions or to coordinate on behalf of the organization anytime people need me.
Thank you, Dr. Brian Dixon. Okay, Wes, you're up with Laura Feldman with an MOC update.
All right, awesome. Well, I think many of the people who have either joined PPA or have been involved with the maintenance of certification process have realized that there's a lot of problems with it. We've had problems that we now think may actually have been illegal. And as a result of that, some physicians have been harmed through this process. And for that reason, a number of physicians ultimately filed suit in December of 2018 against the American Board of Internal Medicine. And that suit is a very complicated and far-reaching lawsuit. We've been fortunate enough to have Laura Feldman from Robinson Curley, the law firm that brought the suit. Yes.
Wes,
yes.
I need to interrupt you for a minute. Listeners, please verify that your device is on mute. There's apparently background noise that's interfering with other people's ability to hear. Thank you, Wes.
Yeah, no worries. So anyway, in December 2018, four internists filed suit against the American Board of Internal Medicine, and the basis of the suit were two allegations, main allegations anyway. It is a class action lawsuit, and it involves antitrust issues and racketeering issues. So I thought it would probably be smart, since most physicians don't know what these things are, to invite Laura maybe just to give us a quick brief rundown of what antitrust and the RICO portions of this lawsuit mean, so that maybe we could have a better understanding before we get into more detail.
Absolutely. So Dr. West, thank you so much for the invitation and for including me in this group. I'm delighted to be here and really delighted to be a piece of this litigation. So as Dr. West mentioned, the first suit challenging MOC was brought against ABIM, and it is a class action and an opt-out class action. And what that means is that any physician, whether a DO or an MD, who has been forced to purchase MOC to maintain his or her initial certification is part of the class unless he or she chooses to opt out. There's a couple exceptions. If you're related to the judge or affiliated with one of the boards, you're not going to be a part of the class. But otherwise, you're in the class unless you choose to withdraw. Subsequent to the ABIM lawsuit, two plaintiffs filed suit against ABPN, which is the Psychiatry and Neurology Board. Dr. Dixon's excited. And then one radiologist filed suit against the American Board of Radiology. And we, along with our co-counsel, are the attorneys challenging those boards' MOC programs. So over the next couple minutes, I'll be brief. I'm going to go over the claims. what's happened so far in the suits, and then the next steps in the litigation. So as Dr. West mentioned, our named plaintiffs brought claims of antitrust violations and also unjust enrichment. And then against ABIM, there's also a racketeering claim. So first, antitrust. So the named plaintiffs in the litigation accuse the three boards, ABIM, ABPN, ABR, of illegally tying the initial certification product to the mock certification product. And what they're alleging is that doctors are forced to purchase mock and jump through all the hoops that mock requires. It's not just handing out some money. They're forced to purchase mock in order to maintain the underlying certification that they purchased. Now, in addition to this antitrust claim, which is a tying claim, they're also bringing a monopoly claim, alleging that these three boards have illegally created and maintained a monopoly power in the mock marketplace, stymieing the efforts of competition like NBPAS. And making it so that other competition can't even enter the marketplace. Now, each of the three suits brings a state common law claim, which is called unjust enrichment, accusing the boards of unjustly enriching themselves at the expense of doctors like you. I mean, just taking money off of your backs and unjustly enriching themselves. Now, the racketeering or the RICO claim in ABIM is stating that ABIM waged a campaign to deceive the public about mock's benefits. So you've heard about their allegations of its benefits to physicians, to patients, to the public as a whole. And part of that racketeering claim is their inappropriate campaign to suggest that mock constitutes self-regulation. I know it's a big buzzword. The complaint alleges ABIM misrepresented what passing mock actually shows, the test's abilities to actually demonstrate doctors' qualifications or their lack thereof. So those suits have been filed. We're in litigation mode. Each defendant has filed a motion to dismiss, and those motions are fully briefed. And what that means is that we have submitted to the court our opposition to the motion to get rid of the suits. And those briefs are pending before the three respective courts, and we're waiting for all three of those courts to decide whether or not to dismiss the lawsuits. We feel like we filed really strong briefs. You can read them online if you'd like. It's abimlawsuit.com or versions thereof, abrlawsuit.com, abpnlawsuit.com. So that's where we are in the litigation. We're waiting for them. We expect it could take several more months. And in the meantime, we are preparing for discovery, which is the phase of litigation where you share information, where we'd be seeking information from the boards and third parties, where they'd be seeking information from us. So sit tight.
Let me ask a quick question, if I may, right off the bat. What do you think the timeline is to start hearing a judge's decision on any of these lawsuits?
Good question. We wish we knew. Litigation is like a lot of hurrying up and waiting. So we're busy, and then we wait, and then we're busy, and we wait some more. We expect ABPN may be the last ruling we'd get because we were just assigned to a new judge that just came onto the bench here in Chicago. So we're guessing, I mean, we're kind of reading the crystal ball too, that we would get ABIM's ruling or the ruling in ABR first. It's our position that we'd be lucky if we hear something by the end of the year, but some judges turn things around more quickly than others. We just don't know if we're number 2 in the pile on the judge's docket or number 200.
Great. Thanks so much.
Yeah.
All right. I'm sure there are other questions out there. Judy, do you want me to allow questions now, or do you want to wait until after the other people give their little briefs, or how do you want to handle that?
Yeah, the last brief that we have to give is the legislative brief by Marion, and she's time constrained. So I think it'd be best to let her make her presentation, and then we'll open it up from there for Q&A for as long as everybody can hang around.
Yeah, also,
Perfect.
Judy, I want to hop in here and say, if everybody's listening, if you do have a question, there is a Q&A option on Zoom where you can just type in your question and just leave it in queue. So definitely utilize that.
Awesome. Thank you.
Okay, Dr. Mass?
Hi, yes, Marianne Mass. I'm just going to launch right in. In December of 2018, the Senate Help Committee, which is the most important healthcare committee in the Senate, put out an APB, a plea to ask for experts to give their ideas for how to reduce waste and cost in healthcare. I saw this as an opportunity. I don't know how most physicians feel, but I sort of feel when I read what everyone constitutes as expert opinion, we end up with a lot of practicing physicians that have no voice. So I partnered up with former PPA advisor David Balot, who's now the head healthcare advisor for Texas Public Policy Foundation, and C.L. Gray, a physician who runs Physicians for Reform. So we crafted and wrote a position paper. Craig Wax was a contributor, and we had 5 main topics, and they were aisle crossers. It's been very important to us all, beginning from PPA, that we are trying to pull physicians together, and there's so much political divide. We picked topics that we felt, and it's not actually difficult in the areas of reducing waste and cost: drug pricing and shortages, the need for transparency, innovative models of charity care, innovative models of delivery and finance, and the physician shortage. Not only did we discuss these issues, but we gave specific legislative solutions. What I've learned over working in Washington, D.C. over the past 4 to 5 years is that very often we go down to D.C., we complain, but we don't give them a roadmap on which way to go. So this paper was used as the basis at the Free to Care conference. I multitasked. I think that comes from my my life as a mom. I'm multitasking right now as the reason I need to go first, just because I have a cross-country meet, and that's why you see me calling from my car. So we make these things happen as we can. So in multitasking, I approached a lawmaker that I've been working very closely with, Congressman Roger Marshall. He's an obstetrician and a second termer from Kansas, and asked if we could put on a symposium, which we did from the Library of Congress in April of this year. The exciting things that have happened since that time. So the authors of the paper and others were put on at that conference to be panelists on those 5 topics. So we had many speakers and panelists, and something amazing happened. That collaboration and bringing people that were leadership from different grassroots groups, we formed the Free to Care movement. The Free to Care movement right now, and hold on to your hats, it is now up to 20 groups, many of them physician-only or physician-led groups, and those 20 groups constitute 35,000 physicians and 2.3 million lives. Think about that for a minute. 35,000 physicians and 2.3 million lives that are connected, that are in agreement on the tenets of that Free to Care white paper. And when we send out the email from PPA telling you, giving you this conference link so you can see it again, we will give you the link to the paper itself so that you can read it. So the idea behind Free to Care is that we're magnifying the voice of patients and physicians to make healthcare personable, portable, affordable, and accessible. Who can argue with that? This has brought us an enormous amount of connection and collaboration. And in addition, a very exciting thing was that in sending it to the Senate Help Committee, they contacted us. They had us come in. I've been in 3 times, and we've opened up a dialogue. And what we hope by this is that we're building a seat at the table for practicing physicians to have a voice in the direction of healthcare reform as it unfolds. Our current plan is for some more conferences. We're going to have an online free fall conference. Exciting for the mock effort of PPA is that it's a free conference, but we're asking for donations, and a portion of those donations will be put towards the mock lawsuit efforts. We're planning on a live spring conference. Both of those will be announced shortly, and we'll be getting information to PPA members. Our spring conference, we're going to have at a bigger venue, so we'll have a first come, first serve, but more than just the 100 seats we were able to get for the small, intimate effort at the Library of Congress. Also exciting, many within our coalition are writing, blogging, podcasting, and we're sharing and amplifying each other's efforts. I will give you out a personal plug and an offer to help. I mentioned that I'm on the editorial board of a newspaper. I don't like consolidation within the healthcare space. I've come to discover the newspaper world doesn't like it within their space. Our small community newspaper is now part of a large consortium, and there's over 500 newspapers around the country. If someone is looking to write guest opinions and op-eds, I have the potential connection in 400 papers around the country to help you get it published. And I think it's so important that not only are we speaking among the physician echo chamber, but getting our word out there to the public. In addition, we're now being sought, because PPA has that 35,000 members, that gets the ear of people and gets their attention, and our voice at Free to Care, and therefore at PPA, we are now being sought to sign on to various legislation, which is exciting, or to sign on in support. So currently we have 3 pieces of prior auth registration that comes from Congressman Marshall and Del Benny. It's a bipartisan approach, and we're supporting, I'll include the bill numbers and names when we give an update after this conference is done, but we're supporting a bill by Congressman Chip Roy, 3594, to help open up healthcare savings accounts, and we're trying to make some impact on a bill that we're not supportive of, 3708, which looks like the wrong solution for the direct primary care world. So that's our update from the. We hope that you feel, as PPA, that we're starting to bring our voices to the table and feel empowered to speak up and send us ideas and thoughts. And we look forward to giving you direction on how to get involved. Thanks so much.
Thank you, Marion. Very nice presentation as always. It's for the listeners, it's really amazing to work with these people and see what they accomplish and watch the progress that's being made. Next up is Dr. Craig Wax, and we're going to go back to maintenance of certification. And after Craig's presentation, we will open up the conversation to questions.
Thanks, Judy, and thanks, Marion, for the honorable mention and the ability to work with you on publishing things and getting significant press and action in Washington. Thank you. I'm going to speak briefly about the AOA, or American Osteopathic Association, lawsuit specific to DOs with regard to Sherman antitrust. That is to say that they tied this maintenance of certification that they've roped in over the last decade to paying dues to the AOA, which, as Laura Feldman can likely tell us, that it's illegal. You're not allowed to make dues to an organization integral with that board certification, as well as if you stop paying dues, that at that point you lose your certification, which is, as we all know, ridiculous. That our goal is certification should be lifelong and should just have CME credits associated, and that's all, because we're all for continuing education, but we're not for profiteering, as Wes Fisher alluded to. So the lawsuit was set up in 2014. I was one of 4 principals in the state of New Jersey. And why did we pick New Jersey? Because we wanted a court that would be friendly to our efforts. We felt that Chicago, where the AOA was, wouldn't be as helpful to our efforts in that way. Plus, we had 2 lawsuits. One was a federal lawsuit with Sherman Antitrust, and then New Jersey has its own mini antitrust that we also engaged. So we had them and we anchored it in New Jersey, which was the brilliant idea of our lawyers at Duane Morris, which is a large international law firm. So our lawsuit was filed in 2015, and as my predecessors have spoken, lawsuits take years and money for sure. The lawsuit went on till 2018, when it was settled after 3 conferences at the Federal Center in Camden, New Jersey. And the results of the lawsuit, which was an opt-out lawsuit, that is to say, all physicians that were board certified were automatically in the class unless they opted out. So the main thrust of the lawsuit was to end the tie of dues and certification, and that was terminated immediately. And as of January 1st, they're terminating the $90 extra certification fee. They're reducing the AOA dues by $90 for at least 3 years. We can't do either of those two into perpetuity, but we could get 3 years, and then the board can make decisions based on their present circumstances. We also guaranteed lifetime certification for all those certified prior to 1997. 1997, unfortunately, was the time when they started the maintenance of certification profiteering nonsense. So we weren't able to change that with this lawsuit, but we have set the stage for further legal action, as you have heard. AOA membership now includes 12 CME credits as opposed to just being $680 for whatever their projects and procedures were, plus $90 certification fee. There's also a multi-million-dollar osteopathic identity campaign that they have money earmarked for to educate people on what osteopathic physicians are, what they do, and some of the benefits that potentially we offer. And perhaps most importantly, we've established a committee of private practice DOs to advise the AOA board on circumstances, because as we all know, the large organizations tend to be primarily academic or hospital system driven folks with a totally different set of priorities than private practice people, DPC people, or even some of their other colleagues that may be in academia. So having said all of that, we accomplished all of those things as of January 1st of the year. So physicians now get to make a choice as to whether or not to be a member of the American Osteopathic Association. It will not affect your certification in any way, and we have effectively ended the tie, which I think basically drew first blood for what it's worth, and has set the stage for further litigation, and hopefully the lawsuit that Wes spoke about, it will help anchor that in reality and give them a stepping stone into their monumentous task on their antitrust issue. So thank you very much. Appreciate the opportunity to speak, and I'll end here.
Thank you, Dr. Wax. So I think we're ready to head into the Q&A, unless, Wes, do you have more that you need to say at this point?
I don't think so, Judy. Thank you. I just want everybody to make sure that if probably a lot of people have already donated to the GoFundMe campaign that we have to support the plaintiffs in all these lawsuits. And certainly I'll give a link to folks afterwards. So I just don't want to forget that part of this, because I think it is a big, we're trying to raise $400,000. We're well on our way, probably over 75% of the way funded. And it's actually quite exciting, but it's taken quite a while to get to that point. But I think now that we have real concrete activity going on at the legal level, I think hopefully physicians will join in and support that cause. That said, I'd like to turn and go ahead and address some of the questions that have been posted. And to the best of my knowledge, I notice others have piped in as well. Dr. Ackerman has mentioned what's the general position from academia in their support for maintenance of certification. And I can only speak for, I'm an employed physician at a large multi-specialty hospital system. I know that probably the vast majority now of U.S. physicians are employed physicians. But this issue has been supported for the most part by most large hospital systems. That is not to say that there are very few, perhaps 1% to 2% of hospitals in the United States that have agreed to allow the National Board of Physicians and Surgeons, the alternate board, to satisfy their maintenance of certification requirement. The way this kind of snuck in and why this lawsuit's important is that initial certification is often required for credentials at hospitals. But the basis of the lawsuit, to my understanding, is that basically what happened is the American Board of Internal Medicine seized an opportunity to extinguish the initial certification or lifetime certification in a financially favorable form for them, and basically got rid of it and made it time limited. And their argument is that it makes people smarter. There's a vast amount of information out there, et cetera, et cetera. And never mentioned that we already had to do continuing medical education as physicians that was of our own choosing, but instead they were going to mandate what education we needed to have, and we had to pay fees. Otherwise, we could not maintain our certification, and that's really where the name came from. And it is that tying of those two products that is the basis of the lawsuit, because since hospitals require board certification, if you can't maintain that any longer, then of course you may not be able to have credentials at that hospital. I know in my large system that is exactly the case. They are still promoting maintenance of certification requirements. In fact, almost strong-arming physicians to complete them, even though they are quite aware of the lawsuits that have been filed. And that goes for all the other places, to the best of my knowledge, these large academic centers, and particularly academic centers, Cleveland Clinic, Mayo, Johns Hopkins, all of them very much support and continue to believe that maintenance of certification is a requirement for their credentialing. And that we believe is a problem because it affects our right to work. You know, this is where the heads are butting legally. And so I hope that answers that question. Because I think large academic centers, there's an interesting, oh, by the way, in that those academic centers that are teaching centers require board certified, ABMS board certified credentialed physician program directors. They've kind of woven it all into that too. So without the program directors being ABMS board certified, you may not be able to maintain your credentials or even have a teaching program, which would affect their government payments. And of course, my fax is firing off right now. I don't know why. So I apologize for that. But anyway, just wanted to let you know that that's the basis of this lawsuit. Next question was ABIM candidates who've lapsed their maintenance of mock or certification. Do you know if the lawsuit will allow those candidates to be recertified without having to take the mock exam? And I don't know, Laura, could you maybe speak to that issue if you have some information that you can provide?
I'm unmuted. Yeah. So just a quick caveat. I'm not in a position, because this is open to the public, to be speaking about our attorney thinking, which is our attorney work product, or our communications with the named plaintiffs, which is attorney-client communications. But what I can say is that each of the lawsuits seeks both monetary relief and injunctive relief, which is non-monetary relief. And the relief that we're seeking in terms of non-monetary relief is the untying or the untethering of this initial certification product to the maintenance of certification products. So the way that the litigation goes is, first we have to survive the motion to dismiss, which we're hopeful we will. Eventually we have to prove liability and then damages, and then the judge or the jury will determine relief, or it will be negotiated as part of a settlement. So that's many steps away, but certainly one of the forms of relief being sought is the untying of the initial and the maintenance of certification.
Awesome. Thank you very much. Marion, I understand that you wanted to contribute a little bit to this conversation.
Oh, I just know that I need to leave in a minute or so, and I wanted to add two things, one for mock and one for our legislative efforts. You know, Wes, you mentioned people donating. Anyone who's listening who has donated, thank you. We hate to ask you for more. Know that all of us have donated, and what we do at PPA is not a paid position. It's a labor of love. We ask one more thing for you on the mock front, and that is, when we're done in a week or two, we're going to be sharing something with you to encourage other physicians that you know. We know you know people from med school, from residency, from fellowship, from your current jobs, from past jobs. Send this on to them. Give your own personal plea. doctor up what we're going to send out that we think will be pretty straightforward, and let them know that they're able to do something. On the same front, if you're interested at all in legislative work, I would ask you, get to know your member of Congress. We're going to be sending you, our white paper is available to you. It has some fantastic aisle crossing ideas. People are looking for solutions. We want you to know your member of Congress at the national level and the state level so that you can start to have an impact. And if there's any questions, I'm happy to speak to PPA members on what's the secret sauce so that you can start to get their attention and make things move and forward those ideas to them. So sorry to interrupt the mock dialogue, but carry on, Wes.
Thanks, Marion. Not a problem at all.
Wes?
Yes, ma'am.
I have a response to one of the questions here, if I may.
Sure.
And the question is from William Gould. Is anyone aware of or part of the health system where credentialing has been removed or is not required or does not require board certification? We're talking about maintenance of certification as a condition for active staff membership. So the answer is yes. I am part of two systems in my community where in the local hospitals, we went through the medical staff and removed the requirement for maintenance of certification for credentialing. And we also have made an amendment to allow NBPAS as a legitimate source of maintenance of continuing our certification as a credentialing option. It has not been challenged in court. A good friend of mine in Houston did allow his maintenance of his MOC to lapse, which I believe necessarily means that the original board certification has lapsed. Is that correct, Wes?
That's correct. I mean, most of these suits or credentialing issues are really initial certification, but because most of them require that by the medical executive committee of a hospital that people be board certified, the maintenance of certification issue is kind of a cloaked requirement that continues because they got rid of initial or lifetime certification. So since the board no longer recognizes lifetime certification except for grandfathered physicians who are received their certification before 1990, we're the younger physicians are tasked with having to continually maintain and make payments to the boards to remain credentialed in most hospitals in the United States.
So my friend in Houston who allowed his certification to lapse was actually called before the medical staff and told that he would be losing his privileges in spite of the fact that legislation has been passed in Texas that disallows the requirement of maintenance of certification for hospital credentialing and reimbursement. But that has yet to be challenged in court, and his hospital medical staff did not change their bylaws, so he's on the hook and having to recertify so that he can support himself and his family before this case faces a court challenge.
Well, I should also say, too, that many of my colleagues, many people across the country have reached out to me saying, hey, look, I'm coming up, my maintenance of certification is expiring. What should I do? And because this lawsuit is not settled and still a long way from being completed, I tell them right now, if it's required in your hospital, you're going to have to continue to do it. And I don't want people to suffer hardship because of the hope that this thing will be completed quickly. So I leave it up to each individual to make their decision what they want to do. Some people, as in one of the plaintiffs of this lawsuit, said, I'm not going to do this because I don't believe it's proper. And that person is now basically unemployed or unemployable. So, you have to decide what you want to do and how strong a stand you want to take personally. But I'm recommending to my colleagues that, look, it's not I would go ahead and re-up now, and then hopefully with the settlement or with the completion of the case, people will be made whole for the kind of pain and suffering and financial problems that they've had as a result of this activity. One other question that came through, which I think is quite interesting, was from Dr. Rico. Will the ABIM principals face criminal liability for fraud, tax evasion, et cetera, if the antitrust violation and racketeering is upheld? I don't know if you can answer that, Laura, but I'll shoot that one off to you.
Sure, it's a legal question. So that our RICO claim, which is the claim for racketeering, is a civil RICO claim. So no, there is not a criminal claim, and the civil claim is only against the boards, not against any individuals.
There you go. All right. So we can type that answer in a little bit, but hopefully that answers the question for folks. Let's see, any other questions that we've received so far? Let's see. As most of the current conversation about healthcare, about how expensive it is, let's see, does the strategy to tie mock ABMS influence with insurance companies as well as macro MIPS as a contributor to the rising costs make sense? I think that as I've blogged before on the Dr. West blog, I think there's pretty clear issues, and I think Meg Edison, a pediatrician out of Michigan, experienced considerable challenges with Blue Cross Blue Shield when she refused to do maintenance of certification. So there is a tie to the insurance companies being able to refuse payment, and that's been pretty well established publicly at this point. So I think, again, it all ties together. So we'll have to see, what happens with the lawsuit. But I think this insurance company influence is of considerable interest because a lot of people may not be aware, but there is a company called ABMS Solutions LLC based out of Atlanta, Georgia, that sells our certification status updated daily to various groups. And I'm sure some of those include insurance companies, although we require discovery to truly understand who's purchasing this product. And that is, to the best of my knowledge, is a for-profit entity that is a subsidiary of the American Board of Medical Specialties. So that is a clear conflict of interest. This is a money-making operation for the boards, and it's also money-making for insurance companies that don't have to pay claims as a result of physicians having their maintenance or their certification status expire. So that's a big deal, and certainly something that we're keeping an eye on.
I wanted to respond to that question. Just one element of Alan Ackerman's question about whether or not this makes sense. It depends on an individual's perspective. And if we all accept and understand that these are revenue generating strategies for these organizations, then yes, it does make sense that they would be behaving in this way. When we look at it from our perspective in terms of efficiency, cost, patient safety, preservation of the patient-physician relationship, no, it doesn't make sense, but they're coming at it from a completely different point of view. And I think it's very important for us to be realistic with ourselves about the perspective that those who are involved in the industrialization of the American medical complex brings to the table. They are in it to make money, and they will do whatever they can to establish and maintain their revenue streams.
There's another question from Christina Dewey. What if we all refuse to pay for mock? And what about the newly passed law in Michigan that Meg Edison helped to get passed? That, to the best of my knowledge, was limited to the pediatric population. And I guess the question really comes to how big a wallet do you have? Because any legal challenge, even if a hospital requires you to do it, is going to obviously cost you some money from a legal standpoint if you refuse to do maintenance certification. Most of us don't have an infinite budget to pay for legal expenses. That's why this particular group effort is so unique in that a lot of physicians are getting together and pushing back against really our own medical industrial complex that we've created from the academic medical centers standpoint. So this is an unusual thing and probably a first ever thing that's happened nationwide for people to try to figure out how we can actually push back against this rolling ball that has just continued to make money for these boards that has shown no additional value for physicians. And so certainly people can refuse to pay for mock if you don't need those for hospital credentialing, insurance payments, or employment, then certainly that's your prerogative. But having the problem with physicians is because PPA represents such a small subset of national physicians, we don't have a majority, and we can't flip a switch and tell everybody, hey, let's just not pay for mock tomorrow. People, unfortunately, have families to feed and kids to put through school, and they don't want to have risk losing their job. So I think the risk to people is too great for them just to refuse to pay for maintenance and certification. That's what I've experienced here.
And you'll remember, Wes, when Meg began her journey and her effort to establish that this was just a revenue generating scheme from the pediatrics board, she did everything that she was asked to do to maintain certification, although she refused to pay. And as a result, she lost her certification. She was working with a group. She continued to work, although payers refused to pay for any claims that were submitted on her behalf. I don't remember exactly, but I think that there may have been even consequences beyond that. But she went through all of the steps necessary to establish that it really wasn't about any educational process at all. It was about the money that they wanted on a yearly basis from her.
Correct. And it wasn't, and with the interesting thing, within paying her fee, within 24 hours, she had both the American Board of Pediatrics and her license and her board certification was reestablished, and she was reinstituted on the insurance panel. The insurance company actually threatened her and sent direct messages to her patients that she was no longer part of their insurance panel. So not only did they use her, but they also used her patients to leverage the requirement for payment of maintenance of certification fees. So that's really quite concerning. So hence why we are in the situation we're in right now. All right.
So we're coming right up on the top of the hour. We would like to wrap it up. There's one unanswered question from Ernest Sussman: in what percentage of PPA is composed of non-surgical specialties versus the surgical disciplines? At this point, we have not differentiated between the specialty subtypes of PPA members. There are many things that can and should be done for the development and growth of this organization. It's a slow process. We're moving along in fits and starts, and sometimes we have the resources to take steps forward, and other times we just have to tread water until we get to the next point where we can move forward again. But we certainly do need contributions, not only for maintenance of certification, but for operational expenses. And one of our desires is to have a full-time executive director who can really begin to do the things that are necessary to make an organization like this run and be as effective as we would like for it to be. So we have created a no barriers to entry membership model. There's just not any reason that any physician in the country can't or shouldn't be a part of Practicing Physicians of America. We do need donations to do the things that need to be done. We have some people that we're working with that are helping us develop not-for-profit revenue generating strategies. There's a lot of work involved. We are all full-time working physicians doing this morning, evenings, weekends. So bear with us as we do what we need to do to gain traction and move into the future. I do want to say that I've been a part of physician advocacy since 2014. And when I came in, there were just a small number of organizations across the country. And now 5 years later, there is what I perceive to be as a traffic jam. Physicians all across the country are, getting their noses up off the grindstone, identifying problems, gathering information, taking action. So there are all kinds of organizations out there to be a part of. And then, of course, Marion made reference to the Free to Care movement that we're all being folded into now, which really looks like it's gaining a lot of momentum and traction. And hopefully, as she said, we'll be able to establish a position at the table for us all the way across our state and federal government, as well as at the negotiating table with the special interests. So thank you. I think that all of our questions have been answered at this point. Oh, I see Laura. Oh, are you saying goodbye? Thank you so very much.
Could I add one?
Please do. Yes, please do.
Okay. Thank you so much. So I want to really emphasize, I don't think I did enough in my initial presentation, how the initial certification product and the maintenance of certification product are really distinct and different. And that's a key element of our litigation. So the two products test very different things. One is in part evaluating the efficacy of the residency program. That's initial certification, whereas mock purports to test whether you are still, up to speed on what's happening in your fields, even though you may have a really niche practice or may not be in the field that you were initially certified in. And there's also distinct demand for the two products, as evidenced by NBPAS only selling maintenance and not selling initial certification, also as evidenced by the fact that these boards sold initial certification for decades and then grandfathered other doctors. So we really view this as two distinct products with different aims, with different goals, with different sources of income, with different things that they're testing. So I'll leave it at that. Thanks so much for including me.
Well, thanks so much for being here, Laura. It's been really added a lot of value to this meeting. And I'm sure as we circulate it around, once we're able to do so, people will at least be able to learn kind of where things are, what this is all about, and hopefully continue our efforts to help the plaintiffs. So thank you again.
Yeah.
So with that, I'm going to wrap it up. Thank you again, John Chamberlain and Brennan Hodges from Citizens Health. And thank you to each one of you who joined us and participated in the conversation. I do see that there's one more question, so I'll jump on there in just a minute because I don't have to leave. I don't know about Brennan. I want to say that I think the most important character trait that's necessary to participate in the movement and do the things that we're doing is courage. We're all putting our jobs and even some people, maybe even our lives on the line to do the things that we're doing. It's new, we're stretching ourselves, we're learning, we're growing, but these are all changes that are necessary for us to become leaders in the development of the new healthcare delivery system in the country. I'm going to look and see what that last question is. Is there a point at which PPA would join forces and resources with the other growing physician advocacy groups? Absolutely. That's Christina Dewey. At our inception, that was entirely the intention of the group. And in fact, it's the best of my recollection that this group was founded at the request of a coalition of leaders of the other physician advocacy groups. But to be very honest with you, I think we've really come up against the wall of human nature. And there's, I believe, some pride of possession involved. The other advocacy groups have put time and money and effort into what they have done and the organizations that they have developed. They don't want to lose autonomy. We created opportunities where they don't have to lose autonomy. But I will say that this free to care movement that has been created, which includes both citizens and physicians, seems to be, once again, a no barriers to entry group and movement where we have seen no resistance to other advocacy groups getting on board and working together in a collaborative fashion. So we do see it happening. I do think the free to care includes citizens as well as physicians. In the end, I do believe that physicians are going to need a unique voice for themselves at the legislative as well as special interest table. Practicing physicians is in position to be that voice, but if somebody else really rises to the surface and takes the ball, we're delighted we'll get on board and be contributors. Thank you for your question. So we've had a couple of other questions come up. Brennan, tell me about your time schedule, and can we just carry on, or do you need to move on?
No, carry on. Let's just continue the conversation. When everything's wrapped up, we can just stop the recording.
Okay. Yes. So we have John Chamberlain forwarded. Please Google free to care. That's FREE, the number 2 CARE.org to learn about that. And let's see, we have an appreciation and appreciate, refuse to pay percentage. So it looks like we have all questions answered. Well, thanks again to all of you who are listening and for taking the time to participate. And we will look forward to speaking with you again when we have our next Zoom conference. Thank you.
Thanks so much, everybody.
Bye-bye. Brendan, thank you. John, thank you very much.
Thank you, everyone.